Hello, this is Vin Bange from Taylor Wessing. Welcome to our webinar today. Today's webinar is part of our regular program where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics, which have included looking at challenges such as connected data, online behavioral advertising and cookies, data security and breaches. Some are more thorny and recent issues like data transfers, safe harbor and the privacy shield, and also the recent times that we've visited the GDPR, amongst many other subjects. And recordings of all those webinars are available if you missed them and still wish to engage with us on those particular topics. In fact, there are some 30 plus webinars to provide amongst our virtual data protection learning bank. Today, we will be continuing on the theme of the GDPR. As you will see from the slide on screen, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering, and we do so from our office footprint, which spans across Northern, Central and Eastern Europe, the Middle East and Asia, and also from our representative offices in the US. And together with the EU, UK and Asia law expertise on the ground, we also provide full-service support from our many specialist law firms across the broader Taylor Wessing network. Today's webinar is brought to you by Taylor Wessing's International Data Protection Practice, and our team advises on all aspects of data protection and information law, and we do so from our office footprint, which is a global 22 partner-driven team, and also complemented by our international network of data privacy law specialists to provide you with a global one-stop-shop solution for data privacy support needs. At Taylor Wessing, we have a dedicated microsite specifically for all things data protection, and that's our global data hub. From this site, you'll be able to access news, which is updated on a weekly basis, look at our written articles and papers on topical issues, where we take a regular look at issues that are raising concerns or challenges in the broader data privacy space. You'll be able to access webinars, events around the world, see where specialists from Taylor Wessing are presenting and attending events, and also for you to be able to register for our forthcoming and archived webinars. We also have many other features on that global data hub, so please do take a look at that at your own convenience. My name is Vin Bange. I'm head of the data protection practice here at Taylor Wessing. I'm delighted to be joined by several colleagues in our data privacy team, Richard Craig, Lucy Lyons, Debbie Haywood, and Stefan Alick from Germany. All are members of our core data privacy team and will be presenting on the different issues to be covered today. So what are we covering today? Well, first of all, Richard Craig is going to be taking a look at the principle of the one-stop shop and the consistency mechanism. Now, this is a development under the GDPR, the General Data Protection Regulation. That is a new development. It's one that promises so much and has been often held as one of the more progressive changes that businesses should and we know have welcomed. Now, Richard's going to explore this area and we'll see if this really is the promised land from a consistency basis. True to the Global Data Hub approach, when we share not only the UK angle but also views from other important EU data privacy jurisdictions. So we're going to be doing that today as well. So following Richard will be Stefan Alick, who is a data privacy expert based in our Hamburg team, and he'll also be providing the German view on the one-stop shop and consistency mechanisms. Then we'll move on to look at the fundamental questions that have been raised in recent years around territorial scope and establishment, which also present themselves as a fairly new concept under the GDPR. So Debbie Haywood will be taking a look at the scope of application and territorial concerns under this upgraded GDPR and what that means in terms of territorial scope, the extraterritorial scope and establishment in particular. Certainly in the UK, we like to see that there is often a carrot or a stick approach towards encouraging compliance and aligning behaviours. And it's hard to find any carrots in the GDPR, but one thing there certainly is, and that is a stick of fines and penalties. And when you see the eye-watering penalties under the GDPR, you'll see why it is going to have quite a fundamental impact on why organizations will change their behaviors toward complying with this new privacy regime. And Lucy Lyons is going to explore this area of enforcement and penalties under the GDPR. Then in usual fashion, we'll have some polling questions to gauge your views. And as always, your views are aggregated so we can share the collective view on specific areas to allow all the fellow attendees to see what everyone is viewing on and saying on those particular points that we will poll for you today. And we'll share those shortly after everyone has the opportunity to take part in that poll. And then, of course, if you have any questions, do send those in as we're going along. And we will, time permitting, answer those questions towards the end of the session. So to crack on with today's webinar and to make a start, I'm going to hand over to Richard, who's going to be looking at the one-stop shop. Richard.
Thanks, Vin. The one-stop shop principle was one of the fundamental elements of the European Commission's original proposals in 2012. The situation under the present directive is that data controllers are subject to regulation by data protection authorities in every EU member state in which they are established. The ability of member states to gold plate the current directive, however, means that controllers established in multiple jurisdictions face inconsistent obligations and best practice guidelines, adding substantial complexity and cost in achieving compliance. This also creates a tendency to multiply the number of regulators investigating a particular aspect of a controller's conduct, and means the controller can face numerous penalties in relation to a single infringement if implemented across several member states. The Commission's proposals for the GDPR, therefore, pursued the admirable objectives of improving the consistency and certainty surrounding the legal obligations associated with processing personal data within the EU. Where data controllers, or indeed now processors, are involved in multi-jurisdictional processing, the Commission's approach involved the allocation of responsibility for the supervision of that processing to a single data protection supervisory authority, namely the one which has jurisdiction in the controller or processor's main establishment. This new approach would be supported by a requirement for cooperation between all supervisory authorities through a consistency mechanism. Unfortunately, despite these noble intentions, the Commission's initial proposals encountered a number of roadblocks when they were scrutinised more closely. The obvious concern, first articulated by the Article 29 Working Party and many others since, was that the requirement for supervision by a single authority would lead to forum shopping, whereby data controllers or processors would ensure that their main establishment would be in a jurisdiction where the data protection authority there was seen as something of a light touch, perhaps being less well-resourced or experienced than another regulator in a more obvious jurisdiction. There were also concerns raised at every stage of the legislative process around the idea of exclusive competence for a single regulator, not only due to forum shopping, but also through concern for the exercise by data subjects of their rights. Say, for example, a data subject in the UK suffers harm as a result of personal data processing by a controller whose main establishment is in the Ukraine. The barriers in terms of geography, language, and understanding of the legal system would make it near impossible for the vast majority of data subjects to enforce their rights. In addition, the Commission had sought to carve out for itself a key role in managing the consistency mechanism itself. It was initially proposed that draft decisions by a regulator in a member state, which may also have an impact on data subjects in another, should be reported to the Commission and the European Data Protection Board. The Commission suggested that it could require data protection regulators to make changes to their proposed measures and ultimately suspend their implementation by that authority by as much as a year. As a result, the Working Party, the European Parliament and the Council all sought to make substantial amendments to the Commission's initial proposals. And the result, after 4 years of negotiations, is a set of provisions which look very different from those first envisaged by the Commission. So, what kind of one-stop shop have we actually ended up with? One of the main concerns highlighted by the Parliament was that individual data protection regulators would be given fully exclusive competence. To address this concern, the Parliament proposed an alternative mechanism. Where controllers or processors are established in multiple member states, or where their processing affects subjects in multiple member states, the main establishment of the controller or processor would be used only to determine the lead authority. The Council approved of this approach, but substantially developed the relevant concepts and procedures suggested by the European Parliament. Crucially, all national data protection regulators retain competence to investigate and sanction breaches of the GDPR if complaints are directly addressed to them, as opposed to lead authority, or if there is an infringement taking place within their member state or which substantially affects their data subjects. We do not yet know what is meant by substantially here, but it is likely to be an area to be clarified quickly in order to avoid disputes over the extent of the jurisdiction of non-lead authorities. Where a non-lead authority wishes to commence an investigation, it must notify the lead before doing so and give it the opportunity to intervene. If the lead chooses not to, the non-lead authority may proceed with its own investigation. If the lead authority wishes to intervene, it will take control of the inquiry and the cooperation procedure will be engaged. The cooperation procedure relies on another new concept introduced during the negotiations, that of concerned supervisory authorities. Lead authorities have a duty to cooperate with concerned supervisory authorities, providing them with information and seeking to reach consensus wherever possible. Lead authorities must also publish draft decisions and give concerned authorities the chance to raise objections with the lead's approach. If a concerned authority does raise an objection, but the lead authority proposes not to act accordingly, it is required to engage the consistency procedure, involving the European Data Protection Board as a conciliator and reaching a binding decision if necessary. However, the lead authority will be permitted to take urgent temporary action in its territory to protect the rights of its data subjects under the urgency procedure. Any such urgent action, and the lead authority's reasoning for it, must be clearly outlined to any concerned authorities and the EDPB without delay. The GDPR also introduces provisions relating to mutual assistance and joint operations. Of course, data protection regulators already provide mutual assistance to one another in a broad sense, sharing information and conducting some joint enforcement activity. However, the GDPR substantially builds on this existing informal network and imposes clear obligations on supervisory authorities. Authorities will be expected to respond to information requests, provide assistance in obtaining authorizations required to conduct investigations, carry out inspections, and to help implement supervisory measures. Such assistance must be provided without delay and in any event within 1 month of the initial request. Concerned supervisory authorities will also have the right to be involved in enforcement operations if the target of the investigation has an establishment within that authority's territory or if its processing affects a significant number of its data subjects, another materiality threshold which is likely to cause some dispute until it is properly clarified. One could certainly predict practical difficulties to arise in at least 2 areas. Firstly, meddling in what may be better termed local investigations by regulators seeking to extend their jurisdictional reach, and secondly, inadequate levels of cooperation by supervisory authorities using their modest resources to prioritize their own investigations, rather than facilitating those of others, which may be expected to have relatively little impact on its own member state. So how does the GDPR propose to deal with such potential disputes? By appointing a referee. So in addition to the already substantial remit envisaged for the new European Data Protection Board, it is now also required by the final text to issue rulings on any disputes that may arise between lead authorities, concerned authorities and the Commission. The EDPB is likely to have its hands full, as all concerned begin to grapple with a complex set of procedures which mark a significant change to the nature of national enforcement over the last 20 years. In order to have any chance of effectively performing this role, the EDPB is a very different entity to its effective predecessor, the Article 29 Working Party. It will have a similar composition, being made up, as the Working Party was, of the heads of the national supervisory authorities and the European Data Protection Supervisor. However, following concerns over the Commission's former influence over the Working Party, the Commission will have a non-voting representative on the board. Its chief remit is to contribute to the consistent application of the GDPR throughout the EU, and in addition to its role in resolving disputes between authorities, the EDPB will be expected to advise the Commission on any data protection issues and examine specific questions referred to it, keep the GDPR under review and provide guidance to supervisory authorities on a range of issues, and collaborate with supervisory authorities worldwide, to name just a few. So, was it all worth it, and how does the one-stop shop measure up to its grand ambitions? Many of the chief concerns around the one-stop shop have been nullified along the way. Exclusive competence has been replaced with a system of lead and concerned authorities who are required to work together, meeting head-on the concerns about forum shopping and the ability of data subjects to exercise their rights effectively. The Commission has also been put back in its box in favour of a more independent and central role for the EDPB. However, the various procedures advocated primarily by the Council now look extremely complex and are highly dependent on the approach adopted by the various supervisory authorities when their agendas may come into conflict. It seems likely that there may, at best, be substantial teething troubles as authorities get used to these procedures, and at worst, some regulators may be insufficiently resourced if they are called upon to provide substantial assistance to others. You could say, however, that the final version of the one-stop shop is a positive step for businesses. Under the current directive, it was the resources and patience of controllers which was stretched by the complex requirements for securing compliance across the EU. Although we have not ended up with a pure one-stop shop, because controllers and processes may still be accountable to regulators other than their lead authority, the final text arguably strikes a much better balance between these conflicting priorities and leaves it to the authorities and the EDPB to bear the majority of the administrative burden. There may also be an element of luck involved in how the one-stop shop is judged once the GDPR comes into force. The majority of cases may turn out to be non-controversial. Establishing the lead authority may be very straightforward, and concerned authorities may be content to trust the lead authority to secure the right result for EU data subjects as a whole. However, if the EDPB is confronted with a high volume of complex cases, with a number of authorities seeking to assert themselves in proceedings, it may become very difficult for the EDPB to keep up. The Board will no doubt be scrambling to provide as much clear guidance as possible to address such jurisdictional issues between now and the summer of 2018. I'll now hand over to Stefan, who will talk about the one-stop shop principle from a German perspective.
Thanks, Richard. Now a few words on how the one-stop shop affects German supervisory authorities. As you may know, we have a lot of them in Germany. We have one on the federal level, which is supervising the federal administration and also some private sectors, such as telecommunications. Then we have one supervisory authority in each of the federal German states, and in Bavaria even two. In accordance with German constitutional law, even federal laws are generally applied by authorities on the state level. When applying the Federal Data Protection Act, the relevant factor for determining which is the competent authority is where the processing takes place, which would usually be on a business premise. And if there's no processing in Germany, the relevant factor would be where the affected data subject lives. This apparently creates a lot of conflicts between the authorities, since, like on the EU level, there are considerable differences in how the authorities interpret the law. There's some very business-friendly authorities in the south and very not very business-friendly authorities in the north. Typical situations in which conflicts between authorities may arise are the following. It might be that different entities of a group of companies have uniform processing activities which might be reviewed by different authorities in different German federal states and be assessed on a different legal basis. The same might happen where we're talking about an entity which has several establishments in different states. And last but not least, problems arise where there's no place of processing in Germany, which means that all authorities in Germany would have competence. The German authorities have found unofficial ways to deal with this situation. The first one is the authority which is competent to supervise the main establishment would usually be deemed to take the lead. The second one is if there's no establishment in Germany, the authorities would agree between themselves on one competent authority. This usually happens regarding the US-American internet companies such as Twitter or Google. So what does the GDPR change? The described unofficial procedures remain applicable in those cases in which only establishments in Germany or data subjects in Germany are affected. But the situation becomes more complicated when the consistency mechanism applies. The German authorities are not all on the board, but have to decide on one representative. So it might happen that an authority that has objected to a draft decision will not be able to decide on this draft decision because it's not on the board, but another German authority is on the board. How to deal with situations like this is currently controversially discussed between the German authorities. And also the question which authority should be on the board is also a question which has not been decided yet. Last but not least, I think that's a problem that most regulators in Europe will face, and Richard also mentioned it. The German authorities currently do not have the resources to deal with EU-wide procedures on a large scale. Now I'll pass on to my colleague, David Haywood, who is going to take a look on the territorial scope of the GDPR. Thanks.
Thank you, Stefan. I am going to look at who the GDPR applies to. You may think it's straightforward, but it's not as straightforward as it might seem. And it's a particularly important issue for non-EU organisations, especially with the enhanced obligations on data processors in the GDPR. Now, over the last few years, we've seen an increasing trend from the Court of Justice of the European Union, or CJEU, and the data protection regulators to apply EU data protection law to organisations which might not in the past have been considered to be within scope. And this is a trend which has been officially enshrined into the new GDPR. Now I'm going to get a bit technical here, so bear with me. As you will see on the slide, the GDPR applies to the processing of personal data in the context of the activities of an establishment of a controller or a processor in the Union, whether or not the processing takes place in the Union. It also applies to the processing of personal data of data subjects who are in the Union by a controller or processor not established in the Union, where the processing relates to the offering of goods or services, whether these are free or paid for, or the monitoring of behaviour which takes place within the EU, and to the processing of any personal data by a controller outside the EU, but in a jurisdiction where member state law applies by virtue of international law, and that covers diplomatic missions or consular posts, for example. So we can look to the recitals which form an introduction or commentary to the legislation to give us a bit more background on some of these concepts. But it's worth saying that the recitals to the legislation are not binding. They're intended to be an aid to interpretation, but it does seem, given, there are 127 of them, that they will be given a great deal of weight in the interpretation of the GDPR as they shed a considerable amount of light on the intention behind the drafting of the main articles. So this is what the recitals have to say on the terms used to set out when the GDPR applies. In terms of what is meant by offering goods and services to data subjects, the recitals explain that the discussion around when EU citizens are targeted by non-EU businesses is one which is often had in the context of consumer and product liability law. For the purposes of the GDPR, this will be where it is apparent that a controller is envisaging offering goods and services in EU member states. The mere fact that a website is accessible from the EU, or the use of contact details or the language used in the country in which the controller is established will not be determining factors. But aspects which can be considered are the possibility of ordering in a different language to the one of the controller's member state, the availability of goods or services in a local member state currency, and any mention of EU customers or particular member states. In terms of what is meant by monitoring behaviour, the recitals state that in order to determine whether behaviour is being monitored through data processing, it should be ascertained whether individuals are tracked on the internet. This includes potential subsequent use of profiling in order to take decisions about the data subjects, or for analysing or predicting personal preferences, behaviours and attitudes. Now we also need to look in more detail at what is meant by an establishment. And the recitals state that this implies the effective and real exercise of activity through stable arrangements. The form of the arrangement, for example whether they are carried out through a branch or a subsidiary, is not relevant. Now, the Data Protection Directive, the outgoing EU data protection legislation, takes a less direct approach to territorial scope than the GDPR. Under Article 4 of the directive, local member state data protection law applies to processing carried out in the context of the activities of an establishment of the controller on the territory of the member state, and where the controller is not established on community territory, where processing takes place using equipment situated on the territory of the member state, unless it's used merely for transit. But the question of what constitutes an establishment has been broadened considerably by recent decisions of the CJEU, which has repeatedly considered the issue at the request of member state courts. And most recently, we've seen the very high-profile cases Google Spain and Weltimo touch on this. Google Spain, otherwise known as the Right to be Forgotten case, considered the issue of processing in the context of the activities of an establishment on the territory. The question in this case was whether the establishment within the EU, in this case Spain, could be held to be processing personal data in the context of the activities of the US parent company Google Inc., even though the processing at issue in the proceedings was completely separate from the processing carried out by Google Spain. The CJU concluded that the directive does not require the processing at issue to be carried out by the establishment, but only that it will be carried out in the context of its activities. The activities of the parent company and its subsidiary are therefore inextricably linked if the subsidiary exists to make the parent company economically profitable. This broad interpretation of establishment in the Google Spain case was expanded on by the CJEU in the Weltimo case, which, despite being submerged by the Safe Harbour judgment, which was released in the same week, is an important decision. Weltimo looked at what constituted an establishment for the purposes of allowing regulators to enforce in their own member states. In Weltimo, the CJEU followed the judgment in Google Spain in giving a very broad interpretation to the scope of the directive and to what constitutes an establishment. This ruling confirmed the Google Spain judgment. The bar for claiming that you are not subject to local member state data protection law is very high if you do business there under current data protection law. The CJU pointed to Recital 19 of the Data Protection Directive, which states that the establishment on the territory of a member state implies the effective and real exercise of activity through stable arrangements, and that the legal form of such an establishment, whether simply a branch or a subsidiary with a legal personality, is not the determining factor. The CJU also said that the presence of only one representative can, in certain circumstances, be sufficient to constitute a stable arrangement, and that crucially, the concept of establishment within the meaning of the directive extends to any real and effective activity, even a minimal one, exercised through stable arrangements. Now, this is the reasoning that we see replicated by the language of Article 3 of the GDPR, so you can literally see the movement from the recital in the directive to an actual article in the GDPR. And what constitutes an establishment is given new importance under the GDPR in terms of the one-stop shop mechanism, which determines which member state regulator has jurisdiction where organisations operate in more than one member state, as Richard has just explained. The place of a controller's central administration in the EU is likely to be the member state of its main establishment, but this presumption can be overturned if the main decision-making in terms of data processing is taken by another member state, and that establishment has the power to have its decisions implemented in other member states. For data processors, again, the default position is that its main establishment will be the place of its central administration in the EU. If it has none, it will be the establishment in the EU where the main processing activities and its role as processor take place, to the extent this processor is subject to specific obligations under the GDPR. What is left open to question, though, is the position of a non-EU company which is caught by the territorial scope of the GDPR and appoints a representative in accordance with the Article 25 requirements. The GDPR defines a representative as any natural or legal person established in the Union who, designated by the controller or processor in writing pursuant to Article 25, represents the controller or processor with regard to their respective obligations under this regulation. The representative must be established in one of the member states where the relevant data subjects are located and should act as a point of contact for regulators and data subjects on data protection compliance issues. And this is without prejudice to legal actions which might be initiated against the controller or processor. But what this idea of a representative fails to capture is the element of control. While the main establishment of an EU entity is determined according to which organisation has control over the data-related decisions and the power to implement them, for non-EU-based companies, the likelihood is that the representative will act in an administrative capacity and will not have much, if any, power in terms of decisions around personal data. Theoretically, it makes sense for this kind of organisation to be regulated in the member state in which the representative is located, but this may not be the member state with the largest number of relevant data subjects. In addition, if the representative is mainly an administrative conduit, while this will qualify it as an establishment for the purposes of the GDPR, enforcement becomes more problematic. The evolution of thinking on issues of territorial scope between the directive and the GDPR by way of the CJEU is clear to see and reflects our increasingly globalised world, with data being slung from location to location, crisscrossing in and out of jurisdictions. We're looking at a very ambitious piece of legislation which seeks quite overtly to exercise control and impose sanctions in jurisdictions beyond the EU when EU citizen data protections rights are at risk. And it will be interesting to see how successfully this is achieved. I'm now going to pass you on to Lucy, who's going to talk in more detail about what those sanctions might be.
Thank you, Debbie. In many ways, it could be said that the GDPR has attracted some of its interest picked up in the media and by businesses because of the increased penalty provisions. The added bite of the GDPR has really propelled it up the list in a lot of cases. This is a method we've often seen in law enforcement. Raise the penalties and conventional wisdom tells you that you'll see higher levels of compliance, or at least intended compliance. Alongside these increased fines, the GDPR has also delivered supervisory authorities the support of the law, which bolsters their threat of action, perhaps increasing the chances of supervisory authorities to demonstrate these powers. In the current climate, it's almost impossible to imagine board meetings in the coming months where the GDPR is not discussed at some level, as the economic repercussions of not doing so could be massive, up to 4% of total global annual turnover, or 20 million euros. Figures I'm sure are familiar to many of you. The data protection governance risk formula looks a little different than the current structure given these increased fines. However, what is yet to be seen is how this newly carved stick is actually handled by the supervisory authorities. Further, how will they act together to enforce the GDPR and penalties for non-compliance across the backdrop of the one-stop shop, as we've explored previously. So let's take a look at the powers under the GDPR for the supervisory authorities. The supervisory authorities are endowed with a number of powers, some of which sound familiar and some of which are new concepts. Importantly, and a change from the current law, some of these powers can be enforced against both controllers and processors, and so processors can no longer hide under the cloak of the controller in the eyes of the supervisory authorities, as they have arguably been able to do so to date. As you'll see on the slide, some of the supervisory authority investigative powers include ordering the controller and the processor to provide any information it requires for the performance of its tasks, carrying out data protection audits, reviewing certifications, notifying controller or processor of any alleged infringement of the GDPR, obtaining from the controller or processor access to all personal data and all information necessary to perform its tasks, and obtaining access to any premises of controller and processor, including data processing equipment. It's possible to see that these powers could be far-reaching. The right of the supervisory authorities to audit companies has been a long-standing source of contentions, but is one which generally supervisory authorities view as essential, even if not used all that often, and one that's clearly here to stay. As well as the investigatory powers, supervisory authorities are also armed with corrective powers under Article 58 of the GDPR. These include the ability to issue warnings to controller or processors that where intended processing is likely to result in infringement of the GDPR, issue reprimands where processing operations have infringed provisions of the GDPR, order controller and processor to bring processing operations into compliance with the GDPR, and significantly this can be directed to take place within a specific time frame if appropriate, order the data controller to communicate a data breach to a data subject, impose a temporary or definitive limitation including a ban on processing, order rectification, restriction or erasure of data, or order a certification body not to issue a certificate, impose administrative fines, and perhaps the hot topic of the moment, order the suspension of data flows to a recipient in a third country or to an international organisation. Again, if we pause to think what these could really mean, these powers could be very extensive. If we take the last point from the list above, the suspension of data flows, how would this really work practically? It remains to be seen how supervisory authorities will really implement such powers. Crucially, supervisory authorities are also empowered to issue substantial administrative fines, which should be effective, proportionate and dissuasive, although, as always, these fines are dependent on the facts of each case. Typically, penalties will only be imposed in addition to or instead of supervisory authorities' corrective powers. When deciding whether or not to administer a fine, there are a number of circumstances that supervisory authorities will consider, which are listed on the slide you can see now. They'll take regard to the nature, gravity and duration of the infringement, the intentional or negligent character of the infringement, action taken by the controller or processor to mitigate the damage suffered, any relevant previous infringements by the controller or processor, the degree of cooperation with the supervisory authority, the manner in which infringement becomes known to the supervisory authority, and whether any corrective powers have previously been imposed on the controller or processor. And there are a number of other factors there on the slide for you. None of these factors perhaps seem surprising, but it is worth taking note of the level of cooperation and interaction with the supervisory authorities that may be expected. There is more value to be placed on better dialogue with the regulator, and companies should think carefully about how they approach this. As always, preparation is always key. So now to look at the fines. There's a two-tier system to fines in the GDPR, and on the slide here you see a list of those infringements of certain GDPR provisions that incur 2% of total global turnover, or 10 million, whichever is the higher, or 4% of total annual turnover, or 20 million, whichever is the higher. Going through some of those on the slide quickly, the lower tier, 2% of total global annual turnover, or 10 million, include informing a data subject that it is not in a position to identify such data subject where it does not do so. So you need to explain where you're not capturing personal data, as well as when you are. The privacy by design and default, if a processor is engaged, the controller shall only use processors providing sufficient guarantees to implement appropriate and technical and organizational measures. The mandatory breach notification reporting system, and the requirement to carry out data protection impact assessments prior to carrying out processing, which is likely to result in high risk for the rights and freedoms of individuals. And then on the right-hand side, you can see a list of the infringements that can attract a fine of 4% of total global annual turnover, or 20 million euros, which include the need for the controller to be able to demonstrate that consent was given by the data subject, the so-called right to be forgotten, the data subject shall have the right to receive personal data concerning him or her, which has been provided to a controller in a structured, commonly used and machine-readable format, more commonly known as data portability. The legitimate transfers under specific exemptions or derogations, and compliance with previous orders from supervisory authorities. So, as we've touched on before, the final versions of the one-stop shop and the lead authority, the cooperation and mutual assistance procedures and concepts are very different from those originally proposed by the Commission, which were intended to produce a completely harmonised regime. The result is that the approach is still somewhat fragmented, and we'll have to wait and see exactly how supervisory authorities implement these fines. There is still a degree of patchwork regulation in the GDPR. Many data protection authorities have long argued for the need for an enforcement regime with teeth, and the GDPR clearly has extra bite. One thing which we haven't seen is how the appeal process will work, which, given the level of fines which could be involved, multi-million-pound fines instead of a couple of £100,000, is likely to be significant for companies. I'll now pass back to Vin and we can go through the polling questions.
Thank you very much, Lucy. So as is usual, it'll be interesting to see how our attendees poll on some of the questions that we wanted to explore with you today, all relating to the topics that we've covered today. And the first question I wanted to look at is to gauge your views on whether it is clear to your organisation as to who your lead authority will be. In other words, which country's data protection authority will be your lead regulator, and whether or not you have clarity on that. So either yes you do, or no you don't have a clear position on who your lead authority will be, or whether it's something that is yet to be evaluated. As we also explored when we talked about lead authorities, but also the concept of concerned supervisory authorities. So again, it would be useful to poll your views on whether it's clear to your organisation which data protection authorities may become concerned supervisory authorities. Again, yes, no, and yet to be evaluated. So for that question, Richard Craig looked at some of the concepts and the differences between a lead authority being just that. It's not a sole authority, but a lead authority. So you can't ignore the other relevant countries that will be applicable to your broader operations and data processing across Europe. So is it clear to your organisation which DPAs may become concerned supervisory authorities? The third question is looking at the point that Lucy was covering, and whether the increased level of fines has raised the attention of the GDPR or data privacy more broadly at executive level within your organisation. So has the increased level of fines raised the attention at executive level? Again, a yes or a no answer to that. And the one point I also wanted to explore, which Debbie covered in more detail today, is will you be caught by the GDPR's extraterritorial reach? So this is a fairly new development, even though we saw some creep of the current law in extraterritorial applicability. But will you be caught by the GDPR's specific extraterritorial reach provision? That's yes, no, or whether that's yet to be evaluated. So please poll away on that, and we will bring you those answers shortly as we compile those questions for you. Whilst that is happening, I'm just going to turn to a few questions that we've had come in, and I'll attempt to answer some of those. First question is the GDPR actually live? And if not, when will it, or when does it go live? So we are reaching the latter stages of the process, as it were. So the European Parliament last week voted through the GDPR text. So all the voting is now done. And now the text that has been finalised and approved will go through its translation processes, so it needs to be translated into the 28 or so different country languages across Europe, and that will take some time. So that will take anywhere between 1 and 3 months. So our expectation is certainly June or maybe even July, we should expect to see the GDPR published on the official Journal of Europe. And the GDPR becomes a live piece of legislation 20 days after it's published in the journal. As we've already explored before, the GDPR comes with a 2-year transitional period. So it will remain in this transitional state. In other words, organisations will have 2 years to implement the directive, so it becomes fully in force and enforceable, subject to fines and everything else from regulators 2 years after that. So 2018, June or July 2018 is when we expect to see that. The other question is, what is the direct impact on financial or private equity institutions, and is there any specific source documentation that outlines that? We have looked at sector-based impacts of the GDPR, and we've covered that on the Global Data Hub. So if you haven't had a look at that, there's a lot of resource there that looks at the impact of the GDPR on lots of different resources. Inevitably, we will see the GDPR impact on almost any environment where we will see personal data being processed. And we know that personal data under the GDPR is to some extent and some degrees broader than what we have at the moment. We can see that its application is meant to be broader than we have right now. So it's difficult to see any sector, any industry vertical that will not be impacted by the GDPR. So if you are, for example, a private equity institution, then whilst you may be in the business of investing and providing equity into other organizations, therefore wondering how it will impact on you, it is inevitable that you will want to consider the degree to which the companies that you're investing into, those companies that you are providing equity into, understand the degree to which those companies are compliant, understand the degree to which those companies have conducted an analysis of how compliant they are against the GDPR, whether they understand the privacy program they will have in place to live up against the GDPR. So again, I would direct you to looking at the Global Data Hub to see what the impact is on different sectors as well. So coming back to the polling questions, we've got some of the preliminary results just coming through, just to give you an idea of what the polling looks like on those particular questions. The first question is it clear to your organisation who your lead authority will be? And interesting response, so 45% of you believe you know or have a clear idea of who that will be. A smaller proportion, just under 20%, believe that you don't understand what that scenario is, you don't know who your lead authority will be. But actually quite a large number, almost 40%, believe that it's something that you still yet to determine. So a vast majority there still need to evaluate how the lead authority role is going to play out for you. Although I think to a degree still reassuring that 45% of you believe you know who your lead authority is going to be. Taking a slight spin on that point, is it clear to you or your organisation whether you're aware which DPAs may be concerned supervisory authorities? And this one not so clear cut, whereas in the previous question over almost 45% of you had a clear idea of who your lead authority will be. Looking at this question of concerned supervisory authorities, only 24% of you have that sense of clarity. Just under 20% say no, you don't have that clarity, but a huge, almost 60% say this is something that you still need to evaluate. And personally, I'm not surprised to see those numbers, because I think this is an element which has been perhaps more of a secondary consideration, or not even a consideration at all, given that we're now seeing how the interaction between lead and concerned supervisory authorities may play out under the new regime. So the third question we looked at is have the increased level of fines raised the attention at executive level? I was hoping to see a vast majority of you saying yes, and that's exactly what we have here. 67% of you say that it has led to increased attention, and that's encouraging to see, although almost a third therefore say that it hasn't yet achieved that result. If you were to look at what the regulators are saying right now in terms of how you should be pitching your steps towards readiness, and if you were to look at the 12-point plan that the ICO revealed in recent weeks, then the first point they raise, and the first point that we've been saying on previous webinars, is grabbing the attention of relevant stakeholders, not only the senior executive, but also those with key responsibilities for the data-rich areas and parts of your organisation. So I still think that there seems to be some work that needs to be done, although an encouraging number to see. The final question I wanted to poll on was, will you be caught by the GDPR's extraterritorial reach? And interesting figures, 37% of you feel that yes, you will be caught, and I think in forthcoming webinars we'll begin to look at what does that mean for organisations who are not necessarily in Europe with boots on the ground, yet they will be caught by this regime and having to comply with the regime as well. So there's 37% of you right now on today's poll fall into that particular category. Only 13% say no, you won't, but there's still a fairly significant 50% of you say that that's something that's yet to be determined. So interesting poll results then. Hopefully that gives you an idea of what your fellow attendees are thinking along the lines of those particular points. A point that we just wanted to also mention, again, there was a question on this, in terms of what's the latest position in regards to the Privacy Shield. And this is an issue which received a bit more clarity only last week. And for those of you who've been keeping on top of this debate, and we had a webinar that delved into this whole safe harbour to Privacy Shield scenario, and we had that webinar just as recently as 6 weeks ago, looking at this issue in much more detail. So, but please do tune into that if you want to delve into this in much more detail and understand that particular journey. But in a nutshell, if I can actually contain this to a nutshell, the Schrems decision late last year saw the invalidation of safe harbour. We then saw the Article 29 Working Party announcing that it was going to provide a period of grace until the 31st of January for organisations to feel a degree of comfort that they won't be prosecuted, but also in that period calling on the regulators, in particular calling on the European Commission and the US negotiators to come up with a political agreement on either fixing safe harbour or with a successor to safe harbour. In early February we saw the European Commission announce the Privacy Shield, a successor to safe harbour. At that stage, or very shortly after, almost within a matter of days, the Article 29 Working Party asked the European Commission to provide a written submission so the Article 29 Working Party could consider in much more detail what the Privacy Shield really meant as a solution. At the end of February, we saw the European Commission release a draft adequacy decision for the Privacy Shield, at which stage the Article 29 Working Party agreed to review this and provide their conclusions by mid-April, and that's the conclusion that we saw handed down only last week. So how could I best summarise what the Article 29 Working Party's conclusion was that was handed down last week? Well, very much a thumbs down is perhaps the best way to describe this. There were some minor positives that can be taken from this, in that the Article 29 Working Party said they were encouraged by the steps taken by the draft adequacy decision, by improving on the safe harbour scheme in the form of the Privacy Shield, particularly in areas such as the rights of individuals and the rights they would have to redress, and also looking deeper at issues around surveillance, which the safe harbour scheme just didn't do with sufficient robustness. But this wasn't enough. And this didn't go far enough as far as the Article 29 Working Party was concerned. And a major sticking point was still issues related to security and surveillance, and matters around bulk data collection and massive and indiscriminate use of data really raised fundamental issues of incompatibility against not only the Schrems judgment, not only against the current directive and fundamental Article 8 rights to privacy, but also leading the Article 29 Working Party to come to the firm conclusion that it called upon the Commission to look at the Privacy Shield proposal again, to revise and revisit in light of these particular concerns, and also for the negotiators to continue their negotiations to reach a point that would be sufficient to overcome the hurdles that have been set out in the Schrems judgment. Interestingly and perhaps unhelpfully, the Article 29 Committee did not provide a view on what a good or acceptable privacy shield could look like. So the uncertainty still continues, and in the face of this uncertainty, organisations are still left to consider those solutions which remain in place. And the Article 29 Working Party said that it wasn't currently reviewing any vulnerabilities or the underlying validity of model clauses, the standard contractual clauses, or binding corporate rules, BCR. They remain viable alternatives to legitimise your data exports. So that brings us to the end of today's webinar. We looked at the Privacy Shield developments in much more detail at our first Privacy Breakfast session of the year here in London, and we did that last week. Our next Privacy Breakfast session will be on the 7th of July in London. An agenda will follow on that shortly, so look out for our ongoing programme of events, including our webinars as well. And our forthcoming webinars are currently looking like the 17th of May, where we're going to look at the interaction between libel laws and data privacy, and on the 21st of June to look at the impact of the GDPR on data processors, which again is a fundamental change from the GDPR compared to what we have at the moment. As always, we will remain nimble to development, so if the Privacy Shield takes another twist or a turn, for example, we will turn our attention and focus back on those points and give them due priority. We do hope you can join us for those webinars and those events, all of which are advertised on the Global Data Hub. So from the team here in London and in Germany, thank you very much and goodbye.